The HOA that tried to steal my land became the kind of story people in town would whisper about for years, but when it started, it was so ridiculous that even I had trouble believing it was happening. I owned 1,500 acres of rural property that had been in my family for generations, a wide stretch of land that included rolling hills, forest, open pasture, and access to a beautiful lake the townspeople always admired. My grandfather bought it after returning from the war, cleared the first road himself, and built the first cabin by hand before running cattle until the land became self-sustaining. It was more than a piece of real estate, it was legacy, sweat, and history, and I had defended it more than once against developers who wanted a slice of the lakeside shoreline. When the nearby HOA came knocking, I thought it would be another good neighbor meeting, one where they wanted permission to run a boat dock or discuss area maintenance. Instead, they sent a letter in an expensive envelope informing me that they had voted to annex my property into their development, and therefore I was expected to pay annual dues, follow their architectural guidelines, and most laughably obey their community rules despite the fact that I didn't live there. At first, I thought it had to be a clerical error or a prank. The HOA was built on the opposite side of the lake, at least 5 miles from the edge of my acreage, and no one had ever suggested I was within any jurisdiction of theirs. They had zero authority, and yet they acted as though they owned the whole valley. I wrote them back a short reply stating the obvious: I was not part of their community, my land predated their development, and I was not paying a dime. I also added that if they wanted to discuss lake usage or shared concerns in the future, I would be willing, but only as neighbors, not subordinates. I expected that to be the end of it. Instead, things escalated. They sent another letter, this time far more formal, claiming that by legal determination, my property now fell within their managed community zone due to a recent internal vote. They included a dues invoice for $4,000 and a threat of daily fines if I did not comply. At this point, I laughed, tossed the letter in a drawer, and went about my business. I had cattle to tend, fence repairs to finish, and winter prep to handle. But the HOA wasn't done. A few weeks later, a representative, an incredibly smug man wearing loafers totally unsuited for dirt roads, showed up on my front porch with a stapled packet of policy pages, telling me that I owed past due fees and that failure to pay could result in legal property action. I asked him to show jurisdiction documents proving that my land, which had never been subdivided or sold outside my family, had somehow come under HOA control. He couldn't. He just smirked and said, "The board voted on it," as if that alone rewrote state boundaries. I told him to leave, escorted him back to his shiny company SUV, and watched him drive off, spinning gravel because he had no idea how to handle a rural driveway. I still assumed it would fizzle out. Nobody could possibly be this delusional. Then I learned I had underestimated them. One afternoon, when I drove into town to pick up feed, I stopped by the courthouse to handle a small zoning form unrelated to the HOA. The clerk, who I had known for years, looked at her computer, frowned, and then looked up at me slowly. "Did you really sell your lake acreage to the HOA?" My stomach dropped. I hadn't sold anything. She rotated the monitor, and sure enough, a filing had been processed indicating that my land had been transferred to the Homeowners Association due to non-payment of community dues and ongoing violations. Someone had forged a document claiming I had defaulted, giving the HOA right to take possession. They had even filed it with a fake signature claiming to be mine. Of course, it was laughably illegal, but the filing itself had gone through because county offices, like many rural counties, were overwhelmed and understaffed. They relied on the assumption that people were honest. The clerk immediately realized something was wrong and put a hold on any further processing, but the shock of seeing my land, my history, listed as sold without my knowledge was something I'll never forget. I went straight to the HOA office, walked through their glass doors, and confronted the board, who were sitting around a polished table like they were running a hedge fund instead of a neighborhood of less than 200 homes. The same smug representative sat back in his leather chair and said, "We followed procedure. You ignored notices, so your land was reclaimed under community governance." I laughed an incredulous, angry laugh. "You people actually think you can steal 1,500 acres because you mailed invoices I never owed?" Their president, a woman who looked like she'd never set foot on anything other than a manicured lawn, adjusted her scarf and said, "We enforce rules. We decide what is best for the neighborhood." I told them neighborhood authority stopped at their property line, but they insisted their annexation vote gave them control. It was like talking to children who had never been told no in their lives. They genuinely believed they were untouchable. What they didn't realize was that they had just crossed the kind of line you can't uncross. I left without another word, drove straight to my attorney, and gave him everything: letters, forged filings, fake notices, dates, names, and all. His reaction said everything. He leaned back, stunned, and said, "They have no idea how deep a hole they just dug." We started preparing filings that afternoon, not just to reverse the falsified transfer but to initiate criminal and civil proceedings for fraud, forgery, slander of title, and damages. What the HOA thought would be a power move turned into a legal noose, and worse for them, they had documented their crimes in writing. The thing about people who think they're above the law is that they tend to put everything on paper. They assume nobody will ever challenge them. But they had challenged the wrong landowner. In just a matter of days, I went from being amused by their ignorance to planning how to take them apart piece by piece. They wanted to pretend my land was theirs. They wanted to bully me with rules that didn't apply to me. They wanted to enforce power they never had. Fine. Now I was going to show them what real legal authority looked like. And by the time I was done, they were going to lose a whole lot more than a forged property filing. They had no idea that their arrogance had already cost them everything. They just didn't know it yet. The legal counterstrike they never expected began the moment I walked out of my attorney's office with the first round of filings already in motion, because while the HOA believed that making fake documents and slipping them in at the county clerk's office was enough to steal 1,500 acres of land, they didn't understand how the law actually worked outside their little gated fantasy world. My attorney, who had spent decades dealing with land disputes, fraud, and property theft, built the strategy like a war plan. The first step was filing motions to reverse the fraudulent sale and lock the titles so nothing could be transferred, sold, or refinanced while the case was active. The next step was putting together a criminal complaint for forgery, fraudulent conveyance, recording false instruments, attempted theft of property, abuse of process, and several other charges I hadn't even heard of until that afternoon. The beauty of it all was that the HOA had documented their crimes themselves. They had sent invoices, letters, and written notices that openly stated their belief that their vote could annex legally owned property, and that failure to pay their invented fees constituted grounds for repossession. Not only that, but the forged transfer they filed had a fake signature that didn't even remotely match mine. They were so overconfident that they didn't bother to hide what they were doing. Within 48 hours, the HOA received notice that the property transfer was under legal challenge and would likely be overturned immediately after the first judge reviewed the filings. But that was just the beginning. My attorney also filed for an emergency hearing with the county judge, a request that was quickly granted once the clerk confirmed the HOA's forged document. That hearing alone sent shockwaves through the county government, because the idea that a neighborhood homeowners association, something generally limited to deciding paint colors and mailbox heights, had tried to steal a ranch the size of a small town was so outrageous that people assumed the situation had to be some sort of satire. Rumors spread fast in small communities, and soon people were talking, did the HOA really try to take his land? Did they actually forge paperwork? How did they think they'd get away with it? While the HOA sat in their meeting room sipping bottled water and imagining themselves land barons, the judge issued a freezing order that stopped them from taking any action on the property until the full case was heard. Lawyers began circling their board members like wolves, and the HOA was forced to hire their own legal representation, something they had likely never prepared for, especially not at the level of litigation coming their way. Behind the scenes, my attorney and I began assembling a massive counteroffensive. We gathered every letter, envelope, meeting minute, policy sheet, and email they had ever sent. We collected witness statements from neighbors, county employees, and longtime landowners who were willing to testify that my land had never fallen under HOA jurisdiction. We pulled historical maps, surveys, water rights filings, homestead documents, and property tax histories going back over a century. Every sheet of paper reinforced the same truth: the HOA had zero claim, zero jurisdiction, and zero right to even send me a bill, let alone file a fake land transfer. But my attorney wasn't satisfied with just proving their action was illegal. He wanted to make sure they paid for what they tried to do. He wanted this to be the kind of case lawyers referenced for decades. And so did I. The HOA, meanwhile, behaved like cornered animals, confused, angry, and still convinced they could bully their way out of it. Their board sent me 3 more demand letters, all threatening additional fines for non-payment, even after the judge had already frozen the title. Each letter only strengthened the case against them. Their arrogance was stunning. They truly did not understand that they were no longer dealing with a neighbor dispute, they were dealing with criminal law, and the system was now fully awake to what they had done. When the emergency hearing day arrived, the courtroom was packed. Ranchers, small business owners, journalists, county officials, and even residents from the HOA showed up. The judge listened to my attorney speak first, laying out the timeline of fraud, complete with evidence projected onto a screen. Then the clerk was called to testify, explaining how the forged deed transfer had appeared in her system. People in the gallery shook their heads, muttered to each other, and looked genuinely stunned. The HOA's lawyer tried to argue that their bylaws gave them authority to govern the community and its surroundings. The judge's eyebrows shot up so high I thought they might fly off his forehead. He asked one simple question: show me the statute that gives a private homeowners association the power to seize someone's ranch because they voted to. The lawyer had nothing. The judge issued a ruling on the spot overturning the fraudulent transfer, ordering the HOA to return any related filings, and warning them that criminal prosecution was likely pending. The courtroom buzzed. The HOA board members looked like they had swallowed whole lemons. But we weren't finished. Over the next few weeks, we filed civil suits for damages, real damages. Loss of marketable title, legal fees, emotional distress, slander of ownership, and financial penalties for every day my land had been illegally recorded as theirs. We sent notice to their insurance providers, informing them that the HOA board had committed intentional criminal acts. Insurance companies do not cover fraud. That meant the board members would likely be paying out of pocket personally. They had played power games with clipboards and meeting minutes, and now they were staring at bankruptcy-level consequences. Word spread through their community. Their own residents began calling emergency HOA meetings demanding answers. How could the board have endangered everyone's financial security? Why had they declared war on a landowner who never had anything to do with them? Why had they falsified legal papers and dragged the entire neighborhood into a lawsuit that could sink property values for years? That HOA board went from strutting peacocks to hunted prey in record time. Meanwhile, we began exploring a new angle, one they never saw coming. The HOA had illegally claimed rights to my land in writing, which meant they had declared that the land and the lake access on it fell under HOA management. If that were true, then every benefit the land provided, including water rights, shoreline access, and development control, could now be subject to legal valuation. Their claim opened a door they should have never even touched. If they wanted my land on paper, then they had just made themselves financially responsible for its market value, which was astronomical. My attorney smiled when he realized it. Their power grab had become a self-destruct button. They thought I was just going to yell and stomp my feet. Instead, we crafted a plan that would make them regret ever learning my name, because the next legal move wasn't just about winning back what was mine, it was about turning their neighborhood upside down in a way they never imagined possible. Selling their mansions out from under them was not a plan I started with, but it became the only logical conclusion once the HOA's own actions opened the legal trap they eventually fell into. When they forged the deed transfer, they didn't just try to steal my land, they legally claimed responsibility and jurisdiction over it in writing. That meant everything that happened next could be tied back to their decision, and my attorney saw an opening most landowners never get. By falsely claiming ownership, they financially entangled their entire HOA with every asset, development right, and liability associated with my 1,500 acres, including the portion of shoreline bordering their multimillion-dollar neighborhood. Once the initial ruling reversed the fraudulent transfer, we shifted into a new phase, assigning real monetary damages based on the value of the property they had attempted to seize. This wasn't petty compensation, it was full commercial valuation, environmental impact, loss of clear title, and restitution for the time and money spent defending a claim that never should have existed. The judge approved a formal appraisal process, and when the certified numbers came back, even I was surprised. The shoreline alone, because it gave rare direct access to deep water sections of the lake, was worth more than the entire HOA development. The final valuation came back at nearly $12 million in combined damages and penalties, and because the HOA had filed the fraudulent deed themselves, the liability fell directly on the association as the responsible party. Suddenly, their residents woke up to discover that the HOA board's power trip had placed their entire community in financial jeopardy. Insurance companies refused to cover the costs due to the criminal nature of the board's actions, meaning the bill had to be paid from HOA resources, and when the HOA couldn't pay, their assets could be seized and liquidated. The board still tried to bluff, holding emergency meetings where they told residents I was being unreasonable and that the courts would surely reduce the judgment. That illusion shattered when the court authorized collection. The HOA was formally informed that if they did not pay the damages owed, their physical assets including shared property, dues income, and even lienable homeowner real estate could be acquired and sold through sheriff's auction. Residents reacted the way any rational people would. They turned on the board with rage you could feel through the walls. Homeowners stood up at meetings yelling, demanding resignations, demanding answers, demanding to know why their six-figure homes were suddenly collateral for the board's stupidity. Board members tried to shift the blame onto each other, claiming different people signed different documents, but the paper trail showed they all approved the fraudulent annexation. Dozens of residents hired attorneys. But none of them could change the core truth: the HOA had committed a crime on behalf of the entire association, and the association was now responsible for the consequences. The first month of non-payment passed, and the court wasted no time. Liens began appearing on HOA common areas, including the clubhouse, tennis courts, lake access paths, and most importantly, the property lots owned by the highest valued mansions in the neighborhood. At this point, I still wasn't trying to ruin anyone's life. I was escalating only because I had been forced to defend my land, my name, and my family's legacy. But the HOA pushed deeper into denial. They refused to negotiate, refused to apologize, refused to accept responsibility. They tried one final maneuver, claiming bankruptcy protection to shield their assets. Unfortunately for them, fraud-based judgments are not dischargeable in bankruptcy court, and the judge rejected the filing within a week. With no payment coming and no legal protection left, the court authorized a public auction of seized properties to satisfy the judgment. The first wave included lakefront mansions, 3 of them, each valued between $1.5 and $3.8 million. These were massive houses with private docks, stone facades, cathedral windows, perfectly manicured lawns, and in one case, a 5-car garage. They were the pride of the development, owned by some of the same people who had voted on the fraudulent seizure in the first place. The day the auction notices were posted, residents gathered in groups on driveways, reading the papers in disbelief. One homeowner screamed at the board president so loudly the police were called. Another homeowner threw a chair through the HOA office window in broad daylight. These were not calm, reasonable people anymore. They were trapped animals realizing their den was on fire, and their own leaders had lit the match. The auction itself was a spectacle. Reporters showed up. Camera crews came. Local news stations interviewed people who once bragged about their gated community but were now sobbing on sidewalks as an auctioneer listed their properties. I didn't attend the auction in person. I didn't need to. I had already given my attorney full authority to bid. When the first mansion came up for sale, bidders whispered when my name appeared on the paperwork. My attorney purchased the first house at well below market value, another at the next auction, and a third was sold to another bidder, the proceeds of which also went toward the judgment I was owed. Some residents still didn't believe the situation was real until the day they watched new owners move in while their former HOA board members stood on the curb holding cardboard boxes and resignation notices. Word spread like wildfire. The homeowners who had supported the HOA's actions began resigning from the board in shame or fleeing before they were individually sued by other residents for negligence and breach of fiduciary duty. The HOA dissolved within weeks. Their charter was cancelled, their officers stepped down, and their corporate filings were revoked by the state because they were no longer financially solvent or legally functioning. The irony of it all was that I hadn't wanted their mansions, their docks, their gates, or their tennis courts. But I had been given no choice but to defend what was mine, and once the legal machine began turning, it didn't stop until justice was served in the same overwhelming scale as the offense. When the dust settled, I stood on the balcony of the first lakefront mansion I had acquired and looked across the water at the land that had always been mine. Calm, quiet, peaceful the way it had been before the HOA decided to play empire. They had tried to seize my ranch with paperwork. I had taken their kingdom with the law. Some people in the county called it revenge. Others called it justice. For me, it was simple cause and effect. If you try to steal a man's land, you should be ready for what happens next. The HOA wasn't ready. They assumed their rules were law. They assumed their clipboards and vote sheets were power. They assumed I would roll over like one of their own residents. Instead, they met someone who had never bowed to a bully in his life, and in the end, the lakefront mansions they once bragged about became the payment for the arrogance that destroyed them.